Welcome everyone. My name is Bahar Azmi. I'm the legal director of the Center for Constitutional Rights. Welcome to this panel entitled Defending the Accused, Storytelling, Community Education, and Advocacy for Criminal Defense. We tried to construct this panel to address the question of criminal defense practice in the context of movement lawyering, which is a bit of a puzzle, because I think we all have in mind this kind of archetypal image of, or an archetypal model of a criminal defense lawyer, which is heavily client-centered, right? The lawyer works exclusively in the interests of one individual client, deploying any and all legal or equitable arguments to limit the legal liability or the sentence of that individual, even where it might be in a conflict with another defendant, caught up in the same course of conduct. And that's not a critique. That is, I think, a critical aspect of our constitutional system, and that we all share the goal in ensuring that individuals engaged in that kind of client-centered representation are adequately resourced and can continue to vigorously pursue that kind of representation, particularly insofar as I think, for example, Kate and Ahmed will stress, that has broader systemic benefits to our system of government. But still, those who represent indigent communities and communities of color surely understand that there are injustices in the criminal justice system that are just that, systemic. That there are sort of class and racial dynamics that disproportionately harm particular communities, and those who are engaged in any kind of, except potentially maybe white-collar criminal defense, any kind of representation of these individuals, see these broader systemic problems every day. So what to do about that? What can individuals and organizations engaged in criminal defense work do to address these sort of broader systemic problems? And so today we have a really sort of rich and diverse set of answers to that question, and we'll engage in a conversation around different strategies to deploy to challenge systemic injustices. Kate Rubin at the Bronx Defenders, their organization offers a sort of holistic defense model, engaged not only in the individual criminal representation of a single person, but offering social support, civil legal services, and other kinds of support for individuals and communities who are at particular risk of being ensnared in the criminal justice system. Or Ahmed Ghapoor, who also traditionally represents individuals, but in a political sense, trying to challenge the sort of architecture of national security and terrorism, the conflation of political activism with terrorism, so that it has repercussions beyond an individual case. Or Linda Sarsour from the Arab American Association of New York, who has been developing community defense models to try and disrupt the sort of pipeline, the post 9/11 pipeline, sometimes loosely referred to as the Moss to prison pipeline. And abolitionists like Brett Grote, who are offering kind of macro challenges to solitary confinement, both the individual prisoners confined, but also to activists, prisoners, families, and allies. So I think we're going to have a really rich set of conversations around these issues. Everyone's bios are in the program. So I think we're going to start with I think we decided we'd start with Kate, and then move on to Ahmed for two perspectives of sort of traditional criminal defense lawyering, but expanded in this more this broader movement context, and then move on to Linda, and then Brett, who are kind of, I think, in a way, bookends. Linda's work is trying to prevent intersection with the criminal defense system, prevent incarceration, and Brett is dealing a little bit with the back end, those who are in fact incarcerated in the most inhumane and brutal conditions. So I've asked each of them to talk a little bit about their organizations and their individual work, and reflect a bit about how their practice tries to address this sort of broader systemic needs or community needs, and what challenges are associated with their work, and then we'll have a conversation and open it up to the full audience. So Kate,
Hi.
start.
Morning, everybody. Nothing.
Morning.
So I actually am going to start with a confession, which came up for me yesterday when I was preparing, and I reread something that Brett wrote to the group in your email when we were preparing a couple months ago. He said one of the things he wanted to do in this panel was explore the challenge of impatience with the status quo in a profession that is steeped in pragmatic rationalization of an intolerable social order. So that was really eloquent. And so I'm not a lawyer. Even though I work at the Bronx Defenders, I work with lots of lawyers. And about 10 years ago, I was working at the Brennan Center, also another legal organization, and I was a couple of years out of college, and everybody assumed that I was going to go to law school, and that was the natural path, and I didn't want to, and I didn't do it, and I wasn't nearly eloquent enough to say that it was because I didn't want to join a profession that was steeped in pragmatic rationalization of an intolerable social order. I knew that, yeah, totally, right? I knew that there was a system, and I didn't want to commit myself to working inside that system. I wanted to be able to work outside that system. And so 10 years later, I manage a civil legal services practice at a big legal organization that has lots of contracts with the city and the state government and some federal grants. So it kind of feels like the joke is on me. And I actually, even though Brett and I haven't met, we talked on the phone. Do you remember? Because earlier this year, after Mayor de Blasio was elected, and a bunch of my friends who also were former outside the system people who now work inside the system were working for the mayor for the transition, and they said, can you help us identify what are the biggest problems at Rikers Island and with corrections in New York City? And can you help us identify people around the country who we could recruit to come and be the corrections commissioner and actually be committed to fixing those problems? So I was in this position of, on the one hand, you can't protest against the system for 10 years, and then when somebody says to you, okay, help us make it better, say, actually, I don't want to get my hands dirty doing that. I would rather just criticize it. But once you actually, right, you can't do that. If you actually want to make it better, you can't do that, I think. We could disagree. That could be a question for the panel. But once you start going down the path of, can I actually find a person in this country who runs a jail or a prison system who I want to put my name behind? And I'm not the decision maker, obviously, right? I'm not choosing the person. But even just to put my name behind it and say, I think this person should be in charge of the system here. That's a really hard thing to do, and I felt awfully close to being in this situation of rationalizing an intolerable social order, or at least not tearing down an intolerable social order, right? At least sort of participating in some way in it. And so it turned out that I don't regret not going to law school. I developed lots of other skills and became an organizer and work on campaigns and did policy reform work, but turned out that avoiding law school and the bar exam didn't inoculate me against basically working inside the system, and sort of that big tension that I think continues to be a huge tension in my work, and I hope we can talk about a little bit on the panel, because I think colleagues and coalition partners and spaces like these are really important for helping us figure out, how do we keep doing this work with integrity and with accountability, even while we sometimes have to make compromises. So I will briefly just talk about the work that we actually do at the Bronx Defenders, because besides being a behemoth legal organization that's, tied up, financially beholden to all these state interests that we want to fight against, we also do, I think, really incredible social justice work every day. So the title of the panel is Defending the Accused, right? And I think maybe you guys asked me to talk on it because if you go to the Bronx Defenders website, it says in like 30-point font, we zealously defend the accused. And we defend the accused, we defend people accused of crimes, of course. We defend parents accused of abusing or neglecting their children. We defend people accused of failure to comply with totally absurd public assistance regulations, and tenants accused of non-desirability in their buildings, and workers accused of misconduct, and immigrants accused of committing crimes of moral turpitude, and based on which they're getting deported, right? And I think even the fact that there's so much language for accusing and criminalizing people pretty much reflects the system that we have, which you guys are all here, so I don't need to give you maybe we could like crowdsource a couple of the statistics on it. Who's got a mass incarceration statistic?
Something in 90% of brown folks.
90% of brown folks?
Everyone goes to jail.
47 million people with a criminal record.
That's a good one. 47 million people with a criminal record. Let's get one or two more. 2.4 million people in prison.
Third highest incarceration rate in the world,
yeah,
behind some traditionally disreputable nations.
Right. So we basically have a system that's like too big to not fail, and it fails people every day. It fails almost everybody that it touches, and it feels like it's planned for failure. And the way that we see it playing out from the public defender side is that across the country there's a crisis in indigent defense, because all of the money gets spent locking people up, and there's no money left to pay for lawyers to defend them. And here in New York City, we have a strong public defender system, not in New York State, but in New York City. But we have a crisis in the courts. And so you get a lawyer, and usually at least a pretty good lawyer, but it's virtually impossible to actually get your case heard, to have a day in court, to go to trial. So, we have this right to a trial, and then tiny fraction of people who are arrested actually get to exercise that right in any kind of meaningful way. And so that kind of, and that's true in the criminal justice system, but it's also true across all the venues where we practice. So family court, housing court, we were downtown this week doing, trying to get one of our clients' cars back at the oath hearing office, with NYPD lawyers bullying our clients to take a settlement. And basically every single venue that we practice in, our clients and our lawyers every day get bullied by court staff and judges and prosecutors and agency staff to take a plea or take a settlement and stop using court resources. And that's one of the things, so I sort of thought about just really quickly 3 things that I think kind of motivate our work, and then 3, don't have answers, but 3 kind of tensions and questions that it brings up for me about criminal defense and movement lawyering. So the 3 things that motivate our work: the right to due process, obviously that's sort of the most fundamental one, but it's not a social justice aspiration, it's just a constitutional right. And that's one that is often you have to fight for, but it's not a social justice thing. Racial and economic justice is, I think, equally drives our work, and we try to do that every day, but in our direct service practice, but we do try to do it through impact litigation and through partnering with groups. And so we partner with Linda as part of Communities United for Police Reform and lots of other coalitions and campaigns. And then I think in some ways the most radical thing we do is fight to keep families together, and meaning keep people home from prison even when they're not innocent, even when they're not just charged with low-level, non-violent things, like pretty much no matter what, we fight to keep people home and out of that system that fails everyone that it touches. And we also fight to keep kids with their parents, even when their parents have screwed up, and kind of even when their parents have screwed up pretty badly, because we also think that it's usually better for kids to be with their own parents, and we think the racism in the criminal justice system is mirrored in the family court system in terms of who gets their kids removed. And the three kind of tensions and questions that brings up for me as a public defender who also is interested in trying to be part of social justice movement is, one, how broad should our mission be as the Bronx Defenders, as a public defender office? Like, how much of that work should get done as part of the organization as opposed to as us individually? And should we be, we fight for police reform, absolutely. Should we be fighting against gentrification in the South Bronx? Should we be fighting to raise the minimum wage? Like, how big should we make it, and what's our role in those other fights? Two, can all of us feel like we're making a difference when we work inside the system? I don't represent people individually. I don't go to court every day. The people in my office who do that, I think they're freedom fighters. They feel like they sit around in courthouses arguing with court clerks, waiting for cases to get called. That doesn't feel like transformative change. And when people burn out, as far as I can see, it's not because the work is too hard or because the hours are too long or because they're not getting paid enough. They burn out because they feel powerless. And the question is, how do we feel like we're really building power, but also stay clear-eyed about how big the challenges are that we are facing? And then the third is, what does it mean to be accountable to communities when our accountability to clients always comes first? And that doesn't come up that often, but it can come up. And it can come up sort of in an individual sense. So, the person who was arrested this week for stabbing 2 kids in an elevator in Boulevard Houses in Brooklyn, like, he will have a public defender, and he is not beloved in his community. That is not a person who the community is going to say, like, do everything you can to defend this guy. But that's your job as a public defender. So, and it always will be. There's no question about the question isn't who do we represent. We always represent our client. The question is just, so then what does that mean about our relationship to the community? And then in terms of sort of social justice movements, you guys probably know about 2 years ago, an NYPD officer named Richard Hayes chased Romarley Graham, unarmed 18-year-old kid in the Bronx, into his grandmother's apartment, shot him unarmed while he was flushing a bag of marijuana down the toilet, and was never indicted of any crime at all. Killed Romarley. And most of our coalition partners in the police reform movement are calling for an independent investigation by the Department of Justice and a prosecution of Richard Hayes. And we aren't part of that as Bronx Defenders, because we feel like even when you've abused your authority as a police officer, the answer to sort of police violence and racism isn't more criminal justice involvement. But, sort of my question is, like, are we right? Is that a correct principled stance, or are we just standing on an abstract principle, and that's not the just thing to do? That's where I'll leave it.
Yikes.
My turn.
Yeah.
Yes. Hi. My name is Ahmed Kapoor. As of a week ago, I live in the Bay Area, and I teach at UC Hastings, where I direct a clinic that provides indigent defendants and their lawyers, more specifically with litigation expertise around issues of national security, and that includes both the counterterrorism and also counterterrorism prosecutions, and also cybersecurity, hacking, stuff like that. It's interesting because I got into criminal defense out of my frustration with civil rights, believe it or not, and the inability, what I felt was an inability to actually make any headway in the national security universe. I started my public interest career in doing Guantanamo representation. I was at a place called Reprieve, and basically it came to a point where we were so stonewalled in the process, specifically after the Obama administration came into the White House, that I felt like I was a glorified pizza delivery man. And in fact, that's a joke that a lot of the Guantanamo lawyers tell each other, like we're just underpaid, obviously, but we go and deliver pizzas to these poor guys that really have no hope whatsoever. We come back to the U.S. and just make a big stink about it in the press, and nothing moves forward. So I got out of that, and I went to do criminal defense work for national security prosecutions here in the U.S. I felt that I kind of felt like a kid in a candy store, because all of a sudden you go from trying to get folks charged with any crime whatsoever to actually having all these charges and like courts and like due process and all this crazy stuff. And so and just one note on that, the cool thing about criminal defense as opposed to civil rights litigation in that sector was the whole idea of state secrets, not being able to get any form of discovery, not being able to actually move forward with any case. Of course, CCR and the ACLU have made some headway. Limited, it's not at all their fault, but I still feel that a criminal defense representation is probably the best way to get access to that sort of stuff. So after going into that field, I kind of realized a couple of things. The first is that trials, the idea of a fair trial does not really work in a racist sort of atmosphere. It doesn't matter if it's a national security case or a regular criminal case. In fact, I just got this guy. Well, cybersecurity is a whole new kind of platform, because when you think of like who the defendants are going to be, most people just envision this white guy or a mask, basically, with anonymous. Which is very interesting if you look at it from a racial dynamic. So basically, what I noticed doing criminal cases was that my partner at the time, Charles Swift, who did the Hamdan case, and I would get into a case kind of midway through when the defendant kind of realized that they were screwed. They were in a lot of trouble. Their lawyer was not doing what they felt was a good job. And so coming into these cases, I didn't realize, it wasn't that the appointed attorney or the retained attorney oftentimes was a bad lawyer at all. It's just that they had no experience doing national security work. They had no experience doing international investigative work. They had never contemplated what foreign intelligence might look like or what classified information might look like. There was a dearth of technical skill in terms of just not only in the cybersecurity context, but also in trying to figure out how this whole surveillance apparatus works. And we're coming more and more to realize that since the Snowden revelations of about a year ago. So I kind of took that gap, and what I wanted to do essentially was kind of fill it with really smart people like the ones that are sitting at this table, and specifically folks at CCR or the ACLU who I regard as some of the best lawyers in the country. And in fact, it was in your office, you weren't there yet, that I was working on a case, and I had this issue, and I ran over to Shane's office because I was just here visiting, and he sat there, and we worked on, we worked through an issue, and I just realized that I wanted Shane to work on all my cases, basically. So I kind of took that, and I wanted to become Shane working on everyone else's cases to fill in that gap, basically, and provide that expertise. So I called Beher, actually, and Beher was a professor at Seton Hall at the time, is that right? Yeah. And I think the way that you coined it, you said that criminal defense attorneys are drinking from a fire hose. In other words, they don't have the time to even begin to challenge these huge constitutional issues that arise in national security and cybersecurity cases. And the two converge, by the way, and if you want to know why, let's just meet afterwards or come to my other workshop later this afternoon. So basically, I kind of created this project and took it to the University of Texas School of Law and went around the whole country monitoring these cases and selecting the few that I felt could make an impact and sort of getting involved in those cases. So in a really strange way, the whole point of my project at UT was to do impact litigation, but through criminal defense. How that works exactly, it's actually, it doesn't work in your traditional civil rights litigation or impact litigation sort of paradigm, because you don't necessarily, your cases don't necessarily result in a favorable precedent that's applied throughout the country and in a way that you can set up or tee up in the civil rights context. But what you do get is amazing access to discovery and law enforcement strategy and prosecutorial strategy that you can then leverage and kind of spread the wealth with other attorneys. So really my clients, or the folks that I serve more, are the criminal defense bar. I mean, I've got clients all over the country, but really the folks I'm trying to provide expertise to are lawyers. And that is meant to trickle down and help defendants and somehow eventually get to some sort of concept of a fair trial, which really doesn't exist for reasons that you'll hear about all today. Although I would, were you the one, Brett, that said, what is it, rationalizing an intolerable social order?
Apparently.
Yep.
Okay, so
documented.
Pragmatically rationalizing an intolerable
I couldn't agree more, but the difference is when you do defense work, or even in the Guantanamo sort of representation context, that rationale is really easy because you got a guy in the hole. And when you go and visit somebody, whether you're bringing pizza or just a friendly face, that's rationale enough for me. Mm-hmm. If I were doing civil rights litigation like that over here, I'd find it very difficult to rationalize my life. No, just kidding. But it would be a little bit more difficult, right? I mean, in that way, if you're jaded by the system, how do you fight within it to make change, right? So you have to rationalize that. For me, I don't really need to rationalize it because I'm just going to go visit my client. If that
so
makes
is it in part the intimacy, the sort of one-on-one solidarity you have with an individual who is desperate?
Well, I think it's a desperation, really.
Mm-hmm.
I mean, who else is going to be there? Mm-hmm. So, whereas in the civil rights context, and sorry to kind of trail off into a tangent, but you're kind of trying to build something. Mm-hmm. You're almost the prosecutor in a way. Well, you are the prosecutor. And I just do not like prosecutors, so it's very difficult. I'm gonna leave it at that, and we can kind of
that's very rich. Okay, great. Linda.
I don't even know where to start. So thank you everyone for being here. So my name is Linda Sarsour. I'm the executive director at the Arab American Association of New York, and I'm also with the Muslim American Civil Liberties Coalition. The Arab American Association of New York was actually founded 6 months before 9/11 happened by a group of very well-to-do Arab Americans who were like, we want to help poor people, let's get together and help them. And then 6 months later, 9/11 happens, so they originally thought they were just going to go out and give handouts to poor people, but then 9/11 kind of changed the dynamic of the organization and what that organization was going to do. The Arab American Association of New York is also located in southwest Brooklyn, so Bay Ridge, which is home to the largest Arab American community in the state of New York, and one of the most heavily targeted by law enforcement agencies post 9/11. And when we talk post 9/11, we mean like the day after 9/11 or maybe the day of, up until now. So it's like 13 years later. And my work comes from a place of, or my personal opinion is that our country post 9/11 created a separate justice system for the Muslim community, whether people want to agree with that or not. And some of those, some of the examples, and I think that validate my personal view and the view of many in the Muslim community, is things like, creating like the NSEERS program, the Special Call-in Registration Program in 2003, which basically asked for males over the age of 16 who weren't legal permanent residents or U.S. citizens to come register with the federal government. People thought they were going to like round us up and put us in like concentration camps, and that was like a real fear. Programs like the New York Police Department's spying program on the Muslim community that includes mapping and sending in informants, not only to the community but into jailhouses, seeking out informants to bring back more information about this particular community. It includes, when the Board of Prisons in 2006 created communication management units, which basically are when Muslim men specifically get into prison on any terrorism-related charges, they get put in these communication management units, which basically means media, no one has access to them. Sometimes even limiting limiting it to like one family member that could have access to you, and only God knows if they actually get their lawyers in there either. And knowing that with such a small population of Muslims in the U.S. that we represent about 85% of those in those management units is another reason why we think there is a separate justice system for Muslims. And also, most often, a lot of the clients that we know of, both in New York and nationally, get indicted or convicted on what we call secret evidence. Like, they don't even know why they're convicted. So how is this a justice system when you're taking away my life and putting me behind bars and you don't even tell me why, and our community doesn't know why, your family doesn't know why? So that's the place that I work from. And I think that I'm also somebody that doesn't have a lot of faith in our justice system, or at least our current justice system. So we have to figure out how to work outside of the system. And the way that we have to do that is that we have to build power and resiliency of community, right, before we get into the place where we're rallying outside a courtroom or packing the courthouse, right? And I think that there is a role for lawyers to play in that. What information does our community have to have? Know Your Rights workshop, people think that that's not important. It's extremely important for people to understand what their rights are, right? We teach the community the system so that they can understand how they have a role in changing and transforming that system. Political education of community, even to the point where we do workshops with many of our friends, including friends here at CUNY Law School out of the CLEAR project, around, agent provocateurs, how to, sniff out informants. I mean, a lot of the entrapment cases, or what we believe are entrapment cases, are because so much resources is going out into communities to validate this, national security, this kind of war on terror. So they have to find cases to validate the millions of dollars, like, for example, the New York Police Department gets. So, when we have, for example, in the mosque, majority, 99.999% of people who are law-abiding citizens who are just trying to make it in this country, and you have this one guy who just happens to be like, but what about our, sisters and brothers getting, killed by Americans in, like, Afghanistan? It's like random, provocateurs everywhere. Or when people or some random guy just shows up in our community and he's starting to ask people specific questions, being able to talk to our community members, not about hiding information, but about not getting themselves involved with informants who put a lot of resources in creating plots, including, the FBI said, for example, on one of the cases here in New York, the Jose Pimentel case, when the FBI was asked by the media, they were like, why didn't you get involved in the case? This is a federal terrorism case. You're the Federal Bureau of Investigation. They were like, look, we didn't want to get our hands on that because that informant was too involved in the case. So when the FBI is criticizing the practices of the NYPD, you probably want to question them too, right? Like, that's probably not the bar, but you know what I'm talking about. So, my confession is I'm not a lawyer either, but people think I'm a lawyer, which is fine. Or maybe it's not fine, I don't know.
You're too cool to be a lawyer.
Being
Yeah,
a lawyer
that's
is
cool.
being not a lawyer is not
cool.
there's no sin in that.
So some of the work, so when I introduced myself also as a member of the Muslim American Civil Liberties Coalition, which was a coalition that started in 2007 after the New York Police Department put out a report, which is quite interesting to read, called Radicalization in the West, a Homegrown Threat. It's online. Some CIA analyst wrote it, and it's 99 pages of red flags of, terrorism. It's like the 4-step process of how somebody becomes a terrorist, and it includes things like growing a beard and like stop wearing hip hop clothing, and people who stop smoking and drinking alcohol, which alcohol they shouldn't have been doing in the first place, but that's a whole other religious conversation we should have. But anyway, the hot spots like taxi depots, cafes, hookah bars, really, like, that's like everybody in our community. But anyway, so that was a really problematic document that we were worried was a prescriptive to law enforcement practices. So basically training law enforcement that these are the things you should be looking for when you're like trying to find terrorists, right? Which is like everybody in our community. So a group of people got together that included attorneys, advocates, and affected community members and said, this is not right. We want you to amend this document, blah, blah, blah. The farthest we went was like some like footnotes in the like end of the report, in which you will see there is an amended document, which of course didn't really go anywhere. And the NYPD continued to say, don't worry, we promise you this is not prescriptive, this is not policy, this is not like a manual. Yeah, right. So then in 2011, we find out through the Associated Press investigative reports that the New York Police Department was engaging in massive unwarranted surveillance of the entire Muslim community in the Northeast, specifically focusing on New York City. For everybody else out there in the world, it was a revelation. For me, it was a confirmation of what our community already knew what was happening, but thanks to the AP, became valid, and we weren't just paranoid that it was actually true. And I think that coalesced the Muslim American Civil Liberties Coalition to start working together, not just to amend this one particular report, but to look at the larger issue of injustice coming specifically from the New York Police Department, and working with attorneys and policy wonks, but also really community and affected community. And some of the experiences that I've had working with attorneys is, and I think it's changed a little bit over the years because of kind of the way and the models that have been emerging, is that a lot of times lawyers come in and they know everything, right? They're the lawyers, they know the system, they know the law, and there's a lot of like dictating to community organizers and to affected community members about what the right thing is to do, right? And for me personally, we work from the place of the people who know what the right thing to do or what's best for people is coming from the people who are most affected by those policies, right? It doesn't, the best solutions don't come from the attorneys that just walked out of law school, right? So the message I'm trying to send, what I've seen as effective models, is when attorneys are sitting side by side with people like the mother of Siraj Mateen, who is currently in prison, another case of entrapment by the New York Police Department of a young 19-year-old Pakistani boy who has an IQ of 78, who actually was targeted in Bay Ridge, which is the community that I come from. Being able to sit and hear from this mother and having her be at that table, to sit with representatives of organizations that are sometimes only human service organizations, but the reason why they're important is because they get to interface every single day with community and hear the stories and the pain of that community to inform the work that's happening on the tables that we sit at. So I think for me, the work starts way before we get into a case where someone in our community is being accused or indicted or has a trial, specifically when it comes to cases around terrorism. Because the difference between when you're doing a case like, for example, you're someone that's accused of, I don't know what the crime is, like abusing your children or whatever. I feel like we still have access to that person in some way, that we get to hear the pain of that mother, and that mother gets to sit in a courtroom. In the cases that we work in, we don't have that access sometimes, right? So sometimes we're trying to build a movement around a case of a person that we can't touch, that we can't see. It takes sometimes years for that person to be put into a facility where community can go in and visit them and be a part of them. Oftentimes their parents and families go in to visit them, but they can't even, they sign some sort of, and Vahid could explain this, I'm not a lawyer, some sort of agreement that they can't even talk about like the condition of that person in prison. Like, we don't even know sometimes if the people we're defending are eating, not eating, getting medication, not medication, if they're happy, they're not happy, if they're reading, they're not, I mean, whatever, even the basics, like we don't have access to that information. So for us, it's really about building resiliency and power in communities, and that's through knowledge and political education. But and this is not a new model, but a new model for the Muslim community, understanding their role in the larger context of the civil rights movement or the movement around ending mass incarceration, or is coalition building. Having a young Muslim, girl or boy see themselves, and their story and their struggles as a community intertwined with the story of young Black and Latino kids in New York City that are being stopped and frisked every day, right? And that work that we're doing in Communities United for Police Reform has really built this beautiful solidarity across communities around having a rally for Romali Graham, asking for the Department of Justice to investigate his case, which I think is, we gotta do that. And having, young Muslim kids standing there, behind Romali Graham's mother, right? And feeling her pain as someone who's the same age as her child. And I think that is how you build power and coalition, and figuring out how to work in a system that is broken. Like, you went to school to learn how to work in a system that is corrupt and broken, and that really breaks down like community, and especially for people that we work with that are coming from countries where their systems are either they don't have a justice system at all, or they have facade justice systems, or they they believe that they came to a country where there was real justice, that there was fairness and equality and due process. They came to a country where they felt like they had the freedoms to stand up to their government, and that's another issue that we deal with, and it's something that I still struggle with every day. How do you get a community that's targeted and oppressed by law enforcement, right? And they have valid reasons to be afraid, to get them to be courageous enough to stand up to government, when in fact there are real circumstances that can get them into the actual fearful situation that they don't want to be a part of, right? So I think that idea of courage is something that I think is fundamental to what we're talking about, because the work that we do requires immense amounts of real courage in a society where people's fears are not made up and not just paranoid, but they're actually real fears. So I'm going to leave that there, and we can talk a little bit more.
Brett, thank you.
I appreciate everybody's comments so far. That's a lot to take in and a lot to try to situate the work that I do in Pittsburgh within that context and to respond to. I'm going to start by giving a little introduction of the work I do and how I got into it, and then I'm going to focus on the storytelling aspect of this panel and try to situate two broad narratives, one the narrative of the state, and two the narratives of those who are resisting the state in the context of the criminal legal system, and illustrate that through stories from casework and organizing work that I'm familiar with. I began getting involved with people in prison, working with an all-volunteer organization, the Human Rights Coalition, the Fed Up chapter in Pittsburgh. There's another chapter in Philadelphia. It's a prison abolitionist, prisoner rights organization founded by prisoners at one of the state's highest security prisons, State Correctional Institution Green, in the year 2000. And I began writing with people in prison. So I had a certain political education about what the criminal legal system was all about, who it targeted, the disparities, how whole communities were subordinated. But the real education I got came from reading these letters about what happens when people are incarcerated. And this has always been a bedrock kind of understanding of what it means to be an abolitionist and what it means to want to target this system based on what its purpose is, what its intentions, its function is. This is not a system that is designed to achieve something called criminal justice, but it's designed to reinforce an unjust and illegitimate status quo based upon a series of oppressive social relationships. But I also understood that you're not going to get others to adopt an abolitionist perspective or anything approaching that if their idea of what happened within the prison system was more shaped by the fantasies on television news or popular media culture. So my first teachers in the law were jailhouse lawyers, and going to law school was not even on the bottom of my list of things that I wanted to do in my life. It just wasn't on the list whatsoever. But after working with people inside for many years and seeing the dearth of legal support they had, and knowing that I had the ability to take on that role and to do it in a different context, I decided to go to law school and to become a lawyer. Despite all the tensions that clearly raises. And so
Confessions all around.
So in 2013, during my last year of law school, I co-founded an organization called the Abolitionist Law Center. We have 2 staff members, a few board members, a growing caseload, and so we've just been thrown right into the midst of civil litigation, for the most part for people who are already in prison. The one thing I want to, so that's a little bit of background of how I came to where I am today. But I want to start by talking about the narrative that the state gives us about what the purpose of the criminal legal system is. This is a narrative that has a number of key features. One, though, to me that is absolutely central is that people in prison, once you are no longer just accused, but convicted, are dehumanized in their objects. They are not individuals who have agency. They are prisoners as a class. They are criminals. They are all lumped together, despite what we've heard about and what people are familiar with, the wide array of ways in which people's conduct is criminalized. It's all conflated together, whether you're in there on a drug offense, a property offense, something related to issues that are rooted in mental health problems and the lack of care, or you're there for psychopathic tendencies and crimes of violence. It's all conflated together. you are not presumed to have any agency, and you often see this amongst reform organizations that are working on the criminal system, right? The voices of prisoners, their experiences are not brought into the narratives about why the system needs to change, oftentimes only as statistics, which of course can be very illustrative, or, you know, as just really horrific stories that are used to advance a policy paper that are oftentimes given to people in positions of power who don't care to change the system because it works perfectly well for them. And in the context of the prison system in Pennsylvania, you are first and foremost a number. You are a prisoner ID number, not a name. We're working on a First Amendment case, and just yesterday I got an email from co-counsel who had overnighted an important document to one of our clients, and she says that she was following up on the tracking and it got rejected, and she was asking why that might happen. And I said, did you put the ID number on? And not having written prisoners, you know, and this is the only Robert Holbrook at the prison, and it's not very complicated to figure out who it should go to, she didn't realize that that would just be rejected, you know, and it was rejected as a matter of course. And when I say dehumanized, I'm not just talking about the conditions that are imposed on them, but I also just mean this as a matter of law, right? You have less human rights than people who are not in prison. That is just a bedrock principle of the way in which the Constitution is interpreted within prison. And it's only really of relatively recent vintage that prisoners have been deemed to have any constitutional rights. Back in the 19th century, the courts referred to prisoners as slaves of the state, and whatever happened inside a prison stayed within prisons. It was the same for most of the 20th century. The doctrine then was known as the hands-off doctrine. The federal courts will keep their hands off of whatever happens in prisons. And that changed in the little bit in the 50s, but then increasingly in the 60s and the 70s. And it was clearly in response to powerful growing movements that were happening outside and inside the prisons in a dialectical relationship in which populations that were subordinated and traditionally shut out from and oppressed by the governing institutions were seeking access. And they were seeking to claim their rights and seeking to have decisions in what was going on in their communities, including if those communities were in prison. And then there's been a rollback since then, right? So the Supreme Court stepped in, codified what sort of constitutional rights prisoners did have, then set a bunch of standards which give a presumption of correctness and deference to prison officials, and which are not designed to protect constitutional rights before they are violated, which, if the system was actually designed to protect constitutional rights, would be that sort of preventative system, right? But it sets a very high threshold, which essentially requires you to have been egregiously harmed. And so, just to talk about solitary confinement for a moment, the standard that exists within the federal judiciary is that you have to be deprived of a basic human need in order to be state an Eighth Amendment violation. So solitary confinement is deemed constitutional. It's not unconstitutional per se. You look at a few factors to determine if it is. If somebody has a serious mental illness or developmental disability and they're placed in solitary, or if solitary confinement causes a serious mental illness, then you have a claim, right? So only after you have been subjected to torture based upon your, psychological vulnerabilities that do not allow you to withstand these conditions as well as somebody else. Or you might have a claim if you've been in there an extraordinarily long time. That's still an open proposition, and the standard that is emerging in some courts around the country is you don't, unless you have a psychological disability or unless one is caused by that. It's the same with due process standards. If you've been put in solitary confinement based on insufficient evidence, based on no reason, based on retaliatory motives by staff, you're not entitled to any due process in the courts until you can establish a liberty interest, which means you have to establish that you have been subjected to an atypical and significant hardship in the context of ordinary prison life. The Supreme Court say go into solitary for 30 days or longer. That's not atypical and significant. It's routine, in fact. So you have to be there for a year, for 2 years in some courts, depending on the particular conditions, before you even have an ability to challenge your initial placement, before you have a liberty interest. Prisoners exercising agency is probably the most threatening thing to the prison system. I mean, the prisoners in Pelican Bay who organized a hunger strike, 3 hunger strikes, in fact. That is the greatest threat to the prison system. One of the cases, the first case that I ever began working on in Pennsylvania was the case of Russell Maroon Schultz. Maroon was a Black Panther, a Black Liberation Army member who was sentenced to life without parole in prison in the early 70s, and he escaped from prison twice, in 1977 and 1980, which is where he was given the nickname of Maroon in honor of fugitive slave communities that existed throughout the Americas. So in 1980 was his second escape. In 1982, he was released to the general population in the prison. Long-term solitary confinement had not been institutionalized as part of the national standard within prisons, and they felt that they could control him within the general population. At this point, Maroon took a different strategic approach to getting out of prison. He was going to follow the rules, he was going to follow the law, he was going to do everything above board and openly, and he was going to organize with lifers and attempt to get advocates and family members on the outside to create a campaign that would lobby for the repeal of life without parole sentences. The lifers organization in the prison went from 5 or 6 prisoners to more than 100, right? When Maroon began organizing them around political interest, around their own interest and the interests of their communities and families that they wanted to return to. Prior to that, they had organized to raise money to paint the cafeteria in the prison, and the prison authorities thought that was great, so they were approved. They shut the lifers organization down eventually. They impeached the old leadership. Maroon was appointed president, and he was put in solitary confinement in the spring of 1983, and he remained there until this February. Right? The only time he was in population was when he was temporarily transferred to the feds, and then he was transferred back to Pennsylvania in '91, and he spent 22 consecutive years in solitary confinement. We had to bring a lawsuit, wage an international campaign with the support of 5 Nobel Peace Prize laureates to get Juan Mendez to begin making, the United Nations Special Rapporteur on Torture, to begin making inquiries, and finally they let this 70-year-old man out. And this is not because he was an escape risk. It was because they feared he was going to incite a slave rebellion, and that his leadership qualities and his ability to work with people who were in prison and oftentimes had what could be referred to as a criminalized consciousness. Maroon had a singular ability to persuade people to turn their lives around and work to having a community-oriented consciousness. And that's just something we've heard again and again and again from people inside prison and people that have been released. Moving on to another aspect of the work we do, we have one case where, there's a couple cases where we're looking to develop a strategy to get back into court and to challenge convictions. This is another case where the government has every presumption in trying to get back to the merits of a case where a prisoner can be fully human and be able to make arguments about why what they've been subjected to was unjust. It's like it's a minefield. It's a procedural minefield. So we have one client, her name's Charmaine Fender. This August will have been 30 years in which she has been incarcerated for killing a man who was attempting to rape her. The facts are a bit messy. She was 18 at the time. She was on a double date with a friend, 2 Turkish exchange students in the city of Pittsburgh, and the one attempted to force himself on her at the point of a knife. She reached under the car and grabbed the gun, fired it out the window as a warning shot, got herself out of the door. The man came after her with the knife in hand, wouldn't stop, so she lowered the weapon and fired. He stopped coming after her. Now, at trial, this was not the prosecution narrative. The prosecution narrative was based on the witness who was in the front seat, who survived, and who was shot afterwards. He began yelling at Charmaine. She was very afraid, very traumatized. The literature refers to this as post-incident behavior, not necessarily knowing what the rational response is to a totally irrational traumatic situation. He tried to flee, and she shot him and wounded him. And then they fled to Virginia Beach, not thinking that they would be believed, probably with good justification, but putting her in a very bad position at trial. She had an attorney who really didn't believe in her innocence. He didn't really argue for her. He didn't make a strong argument. This was self-defense. He didn't ask for an acquittal. He accused his client in the closing argument of being guilty of stupidity and poor judgment. You had to convict her of aggravated assault. He didn't use the R word, rape, at all, except to dispel the idea that this was happening. And for that, Charmaine was sentenced to life without parole based on lies told by the man who was in the front seat, despite the fact that his story and key details had changed when he was talking to the police early on, and then when he was testifying before trial. Certain witnesses were not called that should have been. There was no character witnesses to testify to the fact that Charmaine is a peaceful person for 18 years, never had any criminal record, any violence on her record. There was no expert witnesses about the effects of sexual violence and trauma, despite Charmaine having had a history of that in her childhood, and this being very relevant to understanding the post-incident behavior. So I can tell this story, and I have not really spoken to one person yet, maybe that's the self-selected group that I speak with, right, in which this elicits some sympathy, in outrage, and people wonder how this can persist and go on. We do not have a leg to get back into court unless one or two people are able to give us information that would be considered newly discovered, right? In order to do these types of investigations, you need substantial resources, especially if the key witness lives in Turkey, which he might, right? And Charmaine's case, though, is emblematic of so many other women in prison who are there largely oftentimes because of fighting back against abusive relationships or committing crimes of survival in the context of being in dependent relationships. It's also, in its own way, emblematic of how many people are challenging the underlying grounds of their conviction, and they never get to a merits hearing. They never get the access to the evidence they need. They don't have the resources for appellate counsel or for investigators. A couple of other features real quick of the state's narrative. One is that as a legal matter and also as a social truth the state seeks to impose by having a conviction on somebody is that a prisoner is defined by their crime, by their felony conviction or convictions or whatever it happens to be, that this is the defining attribute of this person as a human being, in anything that happened before or since or in the context of a situation in which a criminal act was committed is subordinate to that truth of the criminal conviction. They are branded and they are permanently marked for a social death in which their legal rights are stripped. This affects their ability to have access to housing, access to food, to government assistance programs, to employment, to vote, to jobs, everything, right across the board. It strips people of civil rights, and that statistic somebody put forth earlier, 47 million people. I mean, that really gets to the purpose of why this system, which is too big to not fail, continues to persist, because it is very effective in traumatizing, stigmatizing, and keeping subordinate a huge sector of the population. So, as an alternative, what are the alternatives? What are the different stories that we can tell? I don't think that there's any case in which you cannot situate it within an anti-systemic analysis, to go on the offensive against what this state is, and to realize that what the government appears to be at its strongest when it comes to issues of using state violence, using force, stigmatizing communities via crime, there's also a weakness to it, right? And that it doesn't stand up to any scrutiny whatsoever. And we have to be unafraid in challenging the notion that this is a system that is even has one of its first, second, or third priorities providing public safety, right? That is just not the case in the least bit. So, and also just in the back end, when you're dealing with people in prison, it's very, very important to, I think, work in a context which highlights their own agency, right? And which works in support of those organizations that are working with them in order to allow them to become, deciders in how they are going to fight this system. So one example from our cases as well is we're doing First Amendment litigation in the state of Pennsylvania. Prisoners not being allowed political literature, stuff being arbitrarily censored. They can't read things that talk about the racism of the criminal legal system because that's racially inflammatory, and will lead to a race riot or guerrilla warfare. These are the actual reasons that are checked off in their boxes. And in the course of bringing this suit, we developed a certain skill set and a knowledge on how to fight these issues. And I was approached by an activist in Philadelphia who does a social justice correspondence course, sending over 100 course readers into prisoners in Pennsylvania. These have social justice curriculum around a number of themes, designed by prisoners, activists, advocates, and we developed a strategy for how to track the censorship that was going on so we could develop a campaign against it. And 40 or 50 of the course readers that were sent in were censored on grounds that ranged from, this isn't from an approved vendor, this isn't an original source, these are photocopied materials, which apparently is grounds for censorship. Maybe these have copyright violations, and apparently the prisons are concerned with enforcing copyright law. And then there was some content-based things too. You know, this inspires guerrilla warfare, is racially inflammatory. And we sent a letter in to the 110 people to track the censorship. And we had just prepared a report, and we were about to, launch our campaign targeting the Department of Corrections for waging a war on learning. And before we could get the report out there, or even make any demand on the department whatsoever, we got a call from their office from their policy director, asking me why the prisons were censoring this material. So she was asking me why their subordinates were doing what they were doing, and then telling us that we want to let this stuff in, we don't want this fight. She sent a memo out to every other mail room within the state saying that you have to let this material in, these aren't sufficient grounds for censorship. So it's because we have a certain skill set and we were able to assist this organization with a problem that wasn't unsurmountable, and the Department of Corrections didn't want this fight. So next time these course readers go out, that's 40, 50 more people who are going to be able to get this material, which is going to assist them in developing reading, writing, critical thinking skills.
Here comes the note.
Yeah. And so assisting them in exercising their own agency and organizing for protection of their own human rights.
Right. Thank you, Brett. So this was sort of an enormously rich contribution, and we're lucky we have a good amount of time for questions from the audience, but I just maybe want to take my moderator's privilege and start a couple of internal conversations, and you all should feel free to react to each other's comments as you see fit. But I want to start with something Kate said, which was just, he said a lot that was incredibly interesting, but I picked up on this that I'd throw out for the whole group, and then I have a couple of sets of conversations I want you to try and engage in. Kate, you said due process is not a social justice thing. It's just a constitutional right, which is just so interesting, and it relates to, I think, how we started this conversation about the archetypal criminal defense model, which is bounded around due process, notice, opportunity to be heard, and in some senses that feels really profound, because without that there's sort of chaos and total arbitrariness. But on the other hand, as I think we've all talked about in our work, it's enormously limited. In the Gitmo context, all everyone was fighting for years was due process. The Supreme Court gave them due process, and we're still reduced to just delivering pizzas, as you say, and it's not ultimately meaningful. And due process in the case of the public defender is sitting around the clerk's office trying to get a calendar and arguing about whether or not something that's so manifestly outrageous is an atypical or significant hardship on the margins. But again, due process is the sort of foundation of our legal system. So is what you're really saying, if due process is not a social justice thing, then is law not a social justice thing? And what does that mean for our work? And sort of brings back to Brett's original sort of statement that we all picked up on: are we rationalizing an intolerable social order? So I'll throw that out there broadly. Then I'd like to start one conversation between Brett and Ahmed, and then another between Linda and Kate. And so Brett and Ahmed, in a way, you represent individual clients, but in somewhat of an impact litigation context. Dare say, using it to tell sort of broader stories. And what is the strategy around that? What is the tension between zealous representation of an individual and sort of trying to develop broader impact litigation stories or perspectives? And for Linda and Kate, you each sort of raised the idea of building power, and Linda talked about a lot of things, but including trying to show sort of commonality in the struggle between Muslim Americans and other oppressed groups, and see connections across their struggles. You didn't talk as much about legal support. And Kate, you talked a lot about the sort of holistic legal support, but a little bit less about, and you even put it out there, how do we build power? What's the role of organizing? And so can you each talk about that other piece that you didn't talk as much about as you're clearly involved in? So Ahmed and Brett, let's take a couple of minutes to address my first question to you.
Your question was about the tension between the
yeah, basically how does impact litigation, you have, I think, impact litigation goals, and how do you do it in the context of an individual case?
So interestingly, when Beher started the introductions today, he mentioned that the criminal defense is sometimes antithetical to the sort of the best interests of your co-defendants. But it's also, in theory, it might be antithetical to the movement, because if your client's interests are contrary to that of the movement, for instance, if the best thing for him to do is to plea instead of fight the actual the unconstitutional charges that are being lodged against him, etc., or her, then you're kind of in a weird, tense spot. In terms of what I do, I prioritize the client. But there are derivative sort of impact results sometimes. So for instance, Linda mentioned the Pimentel case. We worked on the Pimentel case when I was at UT. And the portion on that case that we worked on actually was filing a motion in district court, because throughout the discovery you found that somehow the federal district judge granted a Title III warrant, like a wiretapping warrant, to the NYPD, authorizing the NYPD essentially to wiretap someone without providing who that person was. If you know anything about surveillance law, that's basically saying you can wiretap whomever you want in violation of every single provision of the federal wiretapping statute, basically. And in getting that order unsealed and its underlying materials, we found out through more investigation that this was sort of a routine process that was basically, it could have happened at a diner. You guys ever seen The Wire? You know when they get together with a judge and the judge is like, okay, I'll rubber stamp that? That's exactly what was happening, and that's exactly what is customary practice, evidently, in the Eastern District of New York, which is really interesting. So all this stuff that's happening with NYPD, a lot of what they're doing is based on federal warrants that are being sought after by federal prosecutors through this weird, it's almost like laundering surveillance. So that sort of got an impact tinge to it, to the extent I can then get that to Beher or even Linda to do movement work. But that particular step was not necessarily taken with the impact results in mind. Another case I have, just really quickly, because I love to show off, there was another case I had in San Diego where, and I was working on this for maybe 3 years. I represented this Somali defendant who basically, it was a material support of terrorism prosecution. Long story short, it wound up being that case that that Keith Alexander was touting as the NSA's victory in terms of collecting all of our metadata, essentially. So basically, the NSA collects all of our information, all of our location, etc., numbers dialed, etc., in an effort to stop a cab driver from sending $6,000 over the course of a year and a half. That's why we collect data. That's apparently why. So, and that turned into the first challenge of the NSA bulk metadata collection under Section 215 of the Patriot Act. There was another case just more recently where we had filed. Basically, one of my clients is a journalist who's also alleged to be the spokesperson for Anonymous, which is really the new Al Qaeda, if you guys really think about it, and WikiLeaks. I'm dead serious. And so he was charged with cutting and pasting a hyperlink online while doing his press activities, essentially. And so when we filed that motion to dismiss, 2 days later, the government dropped 11 out of the 12 charges in the indictment. The reason that was an impact is because we got no precedent out of it. It was an embarrassment for the government and enabled us to do a lot of press and show off to a whole bunch of folks at this conference and so on. And also, when you, actually afterwards, but at the end of the day, it didn't create a precedent where the government could not do this again. In fact, they dropped the charges precisely so they can keep charging folks and threatening folks with this sort of conduct. And just to underscore that, the resulting sentence for this journalist would have been 105 years if he was convicted on all the charges. So that's, I guess, sort of the kind of tension.
Correct. Right. What do you think?
Can I ask, before responding, what is the common understanding of impact litigation? How would you define that? Or
I have no idea. I'm not. See, that when we were on the conference call for this panel, I kind of, you weren't on the call,
Right.
but I was like, did Porvy like drag me into this as a joke? Because how am I a movement attorney?
Oh, yeah.
I mean, it could be, right?
Yeah.
I mean, but like, I feel like I try to contribute, but that's not sort of the end goal.
Yeah.
Don't hate me, guys. Don't throw stuff at me. It's just.
Well, do you have any goals in your work beyond, justice for the one human being that you, and I mean, I don't want to answer the question for you, but I think the question is clearly yes,
Systematic
and why,
change.
how, and what are the challenges about? Yeah, systematic.
So, yeah, I mean, using the cases in the litigation to try to further the goals of a broader movement of having structural changes to the way that the prison system operates, or other things that are being challenged. Oftentimes, impact litigation, the way it seems to be discussed, is with this focus on precedent. And this is something that I haven't been practicing that long, but in the cases that we have been litigating and have been preparing, that has not been something that is the center of what our strategic goals are. It's important, and if you can get it, that's great. We had a good decision in the motion to dismiss in the Schultz case, the long-term solitary case. It's just motion to dismiss, lower standard. It's helpful for all the other people in Pennsylvania who are trying to figure out how to challenge their solitary confinement. And one of the ways in which it's helpful is by sending copies into the prisons. And this isn't, based on any sort of brilliant strategic insight. It's more dictated by the lack of resources, our inability to represent all of these people, or to have a broader challenge, the complexities of class actions, the variabilities of their factual situations, but also recognizing that you want to give tools to the people inside the prison themselves, who always have been fighting their situations long before anybody on the outside or any attorney gets involved. In Maroon's case, the meaning of his being released after 22 years and after the movement that even grew to international proportions, right? The meaning is very significant. Its impact, however, on everything else that goes on in the Pennsylvania Department of Corrections around the country is absolutely marginal. They released one 70-year-old man from prison after having substantially suppressed his organizing ability for decades and subjected him to incredible trauma and terrorizing I don't know how many thousands of people through the example of what will happen if you participate again and again and again in unsanctioned attempts to liberate yourself and your community. So that's just something to keep in mind, and to not get puffed up about the abilities of the law or litigation to really challenge something that needs to be uprooted on a much more fundamental level as the consequence of mass movements.
In that case, I might be a movement attorney.
I think so. That's what we said on the conference call.
Well, no,
remember?
you just definitely hit it for me.
Yeah.
But thank you for that. But also using the press is really good. When you have access to, Linda had mentioned actually the not having access to the members of the community, and when as lawyers we actually get that access. If you can somehow maneuver that to circumvent the traditional criminal defense model of never talking to the media and actually using the media in a smart way, which is something I'm a very big advocate of. Then you can actually start to, the court of public opinion and such.
Right.
And you're also litigating specifically to defend the right to organize. I mean, even if you don't win and people don't actually get to organize because of your case, like, I think that is also a part of movement lawyering.
Yeah. So maybe you guys can start your conversation or answer a different question if you'd like, and then we'll have 15 minutes after that for questions from the audience.
Do you want to start talking about building power?
I think Bahrish, I didn't focus too much on this and on like what our role is around like these cases, and I think I mean I just gave you the pre, and then there's also the during and then the after, and I think for us a lot of these cases, you know, most of them, if not actually every single one of them, is a national security terrorism, federal terrorism case. Most often it's about showing solidarity and really supporting the family and trying to uplift the story of, you know, how this person got into the situation they got to. So it's very individualized, although behind it is a much larger opportunity to organize around, organize and get people to understand there's something wrong here, something's just not right. And getting people to kind of understand what is it that's not right, what is it about the system that got this person in there. So on those cases, I feel like it is just an opportunity to use the stories of these people, most often who have very little chance of ever getting out. These are very cases where most often the best options for them, according to their lawyers, is to take plea bargains, right, with the government, including cases like Fahid Hashmi, who I remember, you know, many members of our community standing outside the Metropolitan Center, you know, really confused and wanting to understand why this young, you know, Brooklyn College student who did nothing wrong other than let some guy stay at his house and use his cell phone, right? Not knowing that the guy's bag that had like raincoats and like, I don't know, waterproof socks ends up getting into the hands of some like, I don't know, quote, terrorist group in friggin' Pakistan or something. I don't know. Anyway, the point of the story is that this, what happened to Fahid Hashmi could happen to any of us. Any of us could have our friends ask us, can you let my friend stay at your house while they're in New York? So
can I ask a follow-up to that?
Yeah.
So when you do know your rights, I'm sorry to
No,
interrupt, but when you do know your rights stuff in the community, I always get kicked out of the know your rights teach-ins because I'm like, y'all got no rights,
Yeah, no
sorry.
rights, yeah.
So and it's sort of what you're saying right now. So how do you kind of work that tension out?
Hey, I think the Know Your Rights workshops are not necessarily about you got all these amazing rights. I think it's more about it's a way to give people some sort of tangible like knowledge or information that kind of gives them a little bit more confidence, right? And I think that's what it is. So it's not that they're able to assert, you know, their right, you know, to, you know, not talk to the to the FBI and to, you know, NYPD and law enforcement without an attorney. As simple as that, right? For me personally, if anybody gets anything out of any Know Your Rights training, other than one thing: do not talk to law enforcement without an attorney. Do not let law enforcement in your house without search warrants and all these things. That's all they need. It's not that you're...
Don't consent to a search.
Don't consent, like the basics. So it's not that you have all these great rights and like, you know, use them. That's not really what...
Don't get carried away with
Yeah, don't get carried away with your rights in the United States. But anyway, so back to supporting like current, you know, cases. I think what the end results were around the political education, around these cases, looking at what got these people into these situations, got the community to a point where they then were like, hold up a second, now we want to launch lawsuits and we want to sue people and stuff, like what are we going to sue? So then it takes you to the place where community is, we're on the defense, right? So we're defending our you know, the accused, right? And we're saying they're members of our community and there's an unjust system. But then how do you take that to the next level when the community, those courageous people in our community stand up and say, what got them there are, you know, informants and surveillance programs and the targeting of our community. Let's launch lawsuits against the New York Police Department, which then results into cases like the CCR Muslim Advocates case, which is, you know, Hassan versus the City of New York out of New Jersey. Then it's the Reza case in New York City, which is a group of very wonderful, courageous people who came together as part of a community lawsuit. Like, this is not a lawsuit that the ACLU went on their own and did. We chose the ACLU. We had deliberations in the community about who are the best organizations to rep, including CUNY law schools on that lawsuit as well. And then it took us to another case where how do you connect what's happening to the Muslim community right now to something more historical, something that happened before, which is the case of Barbara Hanshu, the Hanshu lawsuit, right, which happened back in, early 70s, yeah. Right, about the infiltration of political movements and political activists, right, very similar to the what the New York Police Department was doing in the Muslim community. So then you go back, you open this 30-year-old case, you get people to start understanding that this is the same thing, communities providing affidavits to this hand-shoe lawsuit, and now you have a community that for the first time in a very long time is now suing the same system that's putting these defendants from our community in. And I think that's the kind of the evolution of building power. So it's supporting these cases mostly about family and solidarity and understanding that there's an injustice, but then how do you take that to become an impact litigation where you get a class act lawsuit that then tries to change the system? I don't know how and when and if that will happen. But even with the lawsuits, our understanding and the understanding that we have given our communities that you might not win this lawsuit, but this lawsuit is just one slither of a larger movement and strategies and tactics, and it is just one strategy of something much larger. And I think with that understanding and not giving the community too much hope that we're going to win these 3 lawsuits, I think on the hand-shoe one, I think we're going to do good. I don't know. I got some hope. But on the other ones, they're really hard cases. So that's mine.
Awesome. Thank you, Linda. Kate?
So I guess my thoughts about building power are that they start pretty small and then it radiates out. So in terms of our practice, because that's by far the most of what we do is represent individual people, and I think and also the kind of like prototype in your head of criminal defense is that that some kind of like nameless brown person is represented by a lawyer who has a totally overwhelming caseload and can't really do their job even if they want to at all adequately, and they're from the beginning probably being forced to take a plea. And so I think even just starting with, like, we want every single person who we represent to feel like they have power to the extent that you can. I mean, again, like, I want to be clear-eyed about this, like, you're in the criminal legal system, but to feel like they at least have power in their relationship with their lawyer to say, here's what my priorities are. Here's what I want to do with this case. Like, I want to go and try to blow it out of the grand jury, or I want to take a plea because I don't want to come back to court 8 times to fight this weed possession case. I want to go on with my life, even if I have a great issue for a suppression hearing, right? So that each individual client basically has the power at the beginning to define their relationship with the lawyer and to define what their goals are in the process and to kind of define the case. But it obviously goes way out from there, and I think, in terms of really trying to build power to actually change the system, we totally believe that the people who should be making the decisions and should be shaping how the system should change and what justice looks like are the people who are impacted by it. That some of those people are on our staff. That's not the majority who's on our staff, right? And so, then the question becomes, so what do we do to support those movements? The most traditional thing that we've done is work in coalition. So, and I think Communities United for Police Reform is a great example because it's very, like, we're on the steering committee of it, but it was very sort of carefully crafted so that there always have to be 5 organizations on the steering committee, which is the majority of organizations that are grassroots organizations that actually represent people who are directly impacted by racist policing. And then, so we're on there as a legal and policy organization, but we're in the minority. And that, and I think it's important, and even those kinds of things that can get a little bit like Robert's Rules of Orders are really important. It's really important to have intentionality about how you structure things and how you structure who makes decisions. And it's also really important to have resources for grassroots organizing so that those organizations can exist and be robust and do that work. And so I think we also try to do things to help, like, build resources for grassroots organizing in the Bronx. And then, the sort of newer, and I think for us more challenging part of it is trying to actually organize with our clients and build leadership among people who we represent who already know all the problems with the system, who are already angry about it and want to do something about it, and to get those people together and figure out, okay, so what are our strategies and what are the steps? And I'll call out Andres because before he went to law school, when he was at the Center for Popular Democracy, he actually helped as a consultant us think about how to do that. And how to structure and organize, and how to start doing outreach and building contact lists and committees and campaigns and all of that stuff. And that could be sort of a whole other session to talk about the challenges and also really exciting things about doing grassroots organizing work inside a public defender office. But I will say there have been really amazing moments, especially sort of as part of CPR, and it's also really challenging. We've had a really fun time kind of building it and keeping it going.
It's terrific. Really exciting. Okay, so let's take some questions. Andreas, Amam, maybe we can ask 3 at a time, or for now 2 at a time. Okay, Andreas, and then
in the context of, it's particular for Linda, in the context of, not only the criminal justice system and the government making examples of, right, of people and Brett, of people who cross a line, right, but affirmed and perpetuated by mass media that, for the most part, affirms and stigmatizing the government, stigmatizing, traumatizing, keeping subordinate people, and to be afraid and not have the courage to rise up, to stand up, to affirm the rights, minimum rights that they have. And then I was just wondering, like, what it must be so hard in that context, especially, this past week we see, people going after Bardal, right?
He just converted to Islam today, by the way. Just want everybody to know that. Just kidding.
But
He did though.
Oh no.
And the father was, crazy, right? And when the media is so crazy about this stuff, how do you work, and this is deep work, how do you work with people, besides know your rights, to build that courage, that resiliency, and that power? It's just so hard, and I just want to know how, what you're doing right now, and Brett and all of you.
And I want Ahmed to answer that too, because that's totally, in your explosive national security cases, that's the backdrop.
Explosive, yes,
Said it.
Sorry.
It's on tape.
Provocative. Sorry, national security cases. This is why we need Linda in the room at all times.
Charismatic leader.
Yes.
If there were no Muslims in the room, then you can use whatever
Okay.
terminology you want to use. I think that's so. It actually invokes emotion in me when you ask me these kind of questions, because it's something that we still struggle with, and it's about the frame that we work in, right? And the frame of national security, and that frame for me, and I think the way the media portrays it, and just in general, is like when you look at, for example, statistics around stop and frisk, or people's perception of stop and frisk, you're more likely to find people that be like, that's a pretty racist policy, like that's really bad. But then ask them same question about unwarranted surveillance of Muslims, which if you think about it is pretty much the same thing. It's targeting people based on faith, while stop and frisk targets people based on race, right, or ethnicity. And you won't find the same amount of people saying unwarranted surveillance is not good or racist, because people are like, it's in a national security frame. So the frame that's thrown out to the world is like, 9/11 happened, we don't want another 9/11 to happen, right? So it's about your personal security, right? So you start thinking, well, if this policy is about keeping us all safe and we have to give up the rights of a couple of people, then I guess I could live with that, right? And that's kind of the frame that we work in. And I think the way that we not only know your rights is just like a tactic of like building like a little bit of knowledge and power, but it's about organizing from a place of self-worth, right? And the way that we organize with particularly around young people is that we're not asking for favors, right? I'm not asking for anyone for a favor. Like, I'm not, asking for something first of all, I shouldn't already have or I don't deserve. And I think when you organize from a place of self-worth, it starts getting people to think about organizing in a different way. And to be honest with you, this work, regardless of however we want to frame it or however we want to lay it down, it requires courage. I mean, you're going up against power, the powers to be, the same, for us in the context of New York City, I mean, going up against the New York Police Department, which is the largest police force in the country, 35,000 strong. The next largest is LA, which is at 7,000. I mean, just look at the difference of dynamic and power. And I think that for me is the frame that I work from, and we get people to work from that. We work from a place of self-worth and dignity first. And then using these individual cases also, like for example, like after this panel, I'm gonna stay for Philip Agnew's because I love Philip. I just want to hear him. Dream Defenders. Anyway, and I got to go hang out with the Dream Defenders, so I'm very inspired by them. But for example, I'm going to a strategy session with some folks around Javier Payne, right? And he's a recent case of a kid who basically was arrested, and while he was handcuffed, he was like slammed into a storefront. They had to take him to the hospital with holding his chest closed because his chest was open. He's a 14-year-old kid, right? And what the media does, and sometimes, you know, is also perpetrates the actual fear and trying to like push the narrative of the government, which they're always criminalizing our kid. Even Romali Graham, like, do we have to know that Romali Graham was gonna flush a packet of marijuana down the drain? Like, does that have to be part of the story, right? Do we have to know that Javier Payne was getting rowdy with a police officer? Like, does that mean that he deserved to get his chest open while he was handcuffed and slammed to the floor with blood, in a pool of blood? So our people that we're trying to build cases around are people who are always being criminalized by the government on things that have nothing to do really with, I think, with their cases that they had. So when they were running after Romali Graham, were they running after him because he had marijuana, or it was another reason? But the media always plays into like looking at dissecting, you know, when you look at Trayvon Martin, like always dissecting why, you know, like trying to justify the situation that person got themselves into.
Well, and the NYPD always links sealed juvenile records also when people are so.
Yeah, no, totally. My point is when we use stories of like Javier, who's a 14-year-old kid, right, and using his story to organize around, for example, right now we're going to use Javier and with his consent and his family's, of course, like we're not, you know, using him in that term of using, about how we can look at the excessive use of force by the New York Police Department, right? And how this young man who's a victim could become a champion on an issue that's going to impact and continues to impact young people like him and others that are not young, and taking him from a place of being, you know, in the situation that he's in right now where he's being criminalized, right? And not only was he in physical pain, but take him to a place where he becomes a champion of an issue that impacted him. So it's hard, and for some people, they're never going to want to come out and organize, and they're going to let you do it, and then giving people different roles about how they can support the work they do. So not everybody wants to be in a press conference, you know, taking down the New York Police Department. I'm happy to do that. Hopefully it doesn't get me into Guantanamo, but then I'll get Ahmed to hook me up. Like,
bring you pizza anyway. So I haven't forgotten about Ahmed's question, but I want to give Brett and Ahmed an opportunity to respond. If you,
I think Linda hit it right on the head, honestly. But just from the representation perspective, I think that a lot of media are actually interested, and they see the problems in the national security cases, at least from that paradigm. The problem is it's twofold. One is getting the information out, because the DOJ has a policy of issuing protective orders on all discovery in almost all cases. So the very fact of speaking to the press about your discovery or what happened, what went wrong, essentially, in the investigation, it might be in violation of that. The other thing is it's not as visual as throwing somebody through a window, but I mean the reality is, at the end of the day, that the government or law enforcement specifically, when given free rein, they tend to abuse it. So what I tend to do is just wait for that to happen and pick out the stories and kind of feed that. So just to give you one quick example, one in Chicago right now, there's a kid called, his last name is Dawood. He's like an 18, 19-year-old Egyptian kid. He's got a giant fro. And he was essentially entrapped, right? And that's what his lawyers are alleging. His lawyer's name is Tom Durkin, really smart guy. And Tom is a media G, so Tom is on the news every single day saying, what if this kid was an Irish Catholic kid that was, you know, blah, 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 blah. What I like to say is, what if, I mean, it's essentially the equivalent of arresting someone or essentially entrapping them, or laying out a sting operation on a black kid in Harlem on the corner singing, or like following along with Biggie, like if he's about selling crack, right? So all of a sudden that guy has the intent to do that because he's just following along with some dude that's talking about committing a crime, right? Same exact thing with these kids that are somehow confused because everybody says something that the feds then clinch onto, and that becomes the reason that this person is suspect, etc. Right? One more quick example in Baltimore, I represented this guy called Craig Baxham. He was in the military, African American, and then converted to Islam right before being discharged, and traveled to Kenya on the way to Somalia. He had nothing, like zero. And you know about this case. Actually, CCR was going to get involved. But they basically sat him down in Kenya for 4 days and interrogated the smack out of him, like, and pushed him to the extent that they said, well, why are you going to Somalia? Because I want to live in Somalia. Why do you want to live in Somalia? Because I want to practice Sharia law. Okay, why don't you go to Afghanistan? I don't like the food in Afghanistan. He's been in Afghanistan. He doesn't like the food. Okay, so what if, did you know that Al-Shabaab are in Somalia? Yeah, and I like the way that they practice Sharia law. That's fair, right? And then what if, would you fight with them? What do you mean? Islam is a religion of peace, blah, blah, blah. And it's like, what if America were invading Somalia after you went and lived there? Would you take up arms to defend the country with Al-Shabaab? Which, by the way, is not unlawful under the under IHL, under public international law. And he's like, F yeah, I would. And so there you go. Then he basically, on this paper-thin indictment with 4 pages of discovery, gets charged and potentially faces 15 years. This is a case that, and so there's obviously motions to dismiss, blah, 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 First Amendment, da, da, da. And so the judge, because we were right, rather than just dismiss the case outright and repudiate the government, he basically writes us a letter, like an unpublished, published opinion kind of letter to hey guys, this indictment's really problematic. I would urge the government to file a bill of particulars. And for us, that was a huge victory, right? Because I'm a battered child, and I'm like, yes, this is it, right? And the press was picking up on it and all this other stuff. But, and essentially at the end of the day, he pled something that wasn't even terrorism related. But, you know, there are these small, tiny cases. So there is hope, I think, is what I mean to say.
And notice here the connection.
Optimistic.
Yeah, no, this is dangerous. But also notice the connection between Linda's work and Ahmed's work, because the Dawood case is a classic example of the model terrorism prosecution in this country is not about a sort of independent plot. It's one that involves tremendous law enforcement resources around developing informants who get benefits or in some cases are mentally unstable and coercing and pressuring other people to do things they wouldn't otherwise do. It's a construction of the terrorist crime, and Linda's role is to make people aware of that so that they ultimately don't have to wind up.
So just in terms of the conversation that you all were having from Bahir's question to more of a career building angle, you know, as a first year law student, I mean, the thing that's really striking is how hostile courts are to anything civil rights and social justice oriented. And so then the question becomes that if you came to law school to use the law in a court of law for change, it just doesn't look like, oh, well, maybe that's not the way to go. And so could you all just kind of address where do you think a young advocate can be most effective? What methodology is the best? Because it sounds like, you know, these cases are really interesting, but if the courts are hostile, then maybe the storytelling, the documentation, the advocacy is the better route. I mean, just directing it towards us who we don't.
It's all
really
interrelated,
know.
though.
Yeah.
You can't say better or worse. Right?
Yeah, it's all so important, and I think like just to defend my due process isn't social justice issue. Anything that is a basic right that then is denied to a lot of people and specifically based on race, then obviously becomes a social justice issue. So, like including even just like the right to walk around outside of a 5-foot radius or however big it is, less than. And so it obviously is. It just shouldn't be a social justice issue. It should be, but the fact that it is, means that like we need lawyers just doing the much less exciting than Ahmed's cases, the burglaries and the drug possession, like and the iPad quote unquote robbery cases. Like we need that, and we need all these other things.
But also, just more on point to your question. For instance, I have an issue with the entrapment. That word being used, and I would really like for community organizations and advocacy groups that are lawyers to better understand what that means, so that they can when they actually make that claim, they can actually move the public, as opposed to being called just like radical crazies. You know what I mean?
Right.
You know, well, I think you posed the distinction between lawyering and maybe documentation, storytelling, advocacy, and there's been acknowledgement these are interrelated, but it reminded me of, I mean, the comment Ahmed made earlier about not being afraid to talk to the press, which is the traditional model of criminal defense. Having come to law school in legal practice through an organizing background, grassroots background, like, it makes perfect sense that you want to go to the press. To be fighting for your clients, to be exposing the injustices and hypocrisies. And I never cease to be amazed by how many people I know in Pennsylvania, you know, people in prison that are fighting their convictions. There's frame, there's an extraordinary amount of evidence, they're fighting to get it heard in the courts, and their lawyers are trying to shut down anything that they can't control. They don't want you talking to the press. They think it's somehow going to antagonize the prosecutors who are already trying to keep their clients in prison until they die. So there's all sorts of issues with that, but for me it raises the role of lawyers as gatekeepers. And lawyers have access to a skill set, to an incredible amount of knowledge and information, and if it is not shared with communities, not shared through effective advocacy and storytelling, it's going to allow the system to perpetuate itself. And the most effective ways to point out the injustice that's going on and what people are doing to fight back is just what you've been hearing people do tonight, is to tell the stories about the system itself, and to really tell them in human terms. And that gets back to the question earlier about courage. How do you encourage and stimulate courage within the people that you're working with and being impacted by the system? And for me, it goes in the other direction. It's the courage of people in the most impossible of circumstances standing up that make the choices that I make very easy. It's effortless, right? When you visit somebody who's lived in a concrete tomb for decades, and they have an incredible amount of humanity and intelligence and warmth, and are far more aware of the social and political conditions that exist in communities they haven't literally physically been in for more than 40 years, right? It makes the notion of filing a lawsuit or making, a nasty comment about the Department of Corrections in the press like a no-brainer, right? And so by highlighting those individuals who do take those stands, that's one way. By highlighting that example, that reverberates to others who hear about it. And oftentimes the way they hear about it's not through the press, right? It's not through the capitalist press. It's the movement literature, it's the activist stuff, the newsletters and whatnot that go out. And, communities build up an ability to see through the dominant narrative, but that happens through years and years and decades of self-organizing activity. And I've been reading the history of Venezuela recently, which just really brought this out in the most dramatic way in 2002, when there was a coup and Chavez was removed from power for a couple of days, and the media were key organizers and instigators of this coup, and they shut down any coverage of resistance in the street. They fabricated a narrative of violence ordered by Chavez, and the people just weren't having it because they had been preparing themselves for struggle against the elite oligarchic rule for decades and decades, and they had their own forms of organization, so they weren't going to be taken in by that. And so a lot of what we do right now for a long period of time has been organizing, and it's been failing to achieve our larger goals, but in doing that we are working to build up the capacity for communities to resist, to tell and believe their own stories, so that the failures are just going to be precursors to larger victories in the future.
Yeah. And I'm on to sort of expand your question / critique, and these conversations are not happening much in the law school curriculum, and I'm sure you've noticed that in your civil procedure lectures, and so part of the goal of this conference and this broader project is to expose you and law students to these alternative, courageous ways of engaging in activism and lawyering. We're ending on a bit of an optimistic note here, which is not often not always, let alone often the case in these kind of panels around criminal defense lawyering, particularly ones that invoke Guantanamo. But you've heard just a sort of an enormous range of really courageous, proactive ways of engaging in social justice activism and lawyering, whether it's through individual using due process to get individual justice for someone, keeping him or her out of jail for 3 or 4 days so he or she can be with her family and support family and community, building power in the Arab and Muslim American community across the struggles, changing the culture of the criminal defense bar, dealing with these clients, and resistance and storytelling are all sort of modes of political lawyering that you can be engaged in and you can spend your whole life thinking about and improving on. And so that's the takeaway. We just want to thank the panel for those really marvelous contributions and their work.